Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, June 28th, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. Now, since the beginning of January, I've been holding these weekly live stream broadcasts every Thursday evening to try to keep up to date with the latest Supreme Court news. And usually I try to cover everything significant that's happened at the court in the past week. But because this was the last week of the term and there was just so much happening at the court, I decided to break things up a bit this week. And so I actually had two live streams earlier this week. On Monday night, I did a live stream covering the 4 decisions issued by the court last Friday, June 22nd. And then on Wednesday night, that's yesterday, I did another live stream covering the 6 opinions the court issued this week on Monday, Tuesday, and Wednesday this week. Now, if you want to hear about those cases, and this includes some very big ones, big high-profile cases that all came down at the end of the term, then please check out the last 2 episodes available on the Counting to Five YouTube page or through the audio podcast. But tonight, we're not going to talk too much about the cases. We're going to wrap things up with a look back at the just completed term, a look ahead to next year's term, and a short discussion of the biggest news of the week, and that's yesterday's retirement announcement from Justice Anthony Kennedy. So that's basically what's on deck for tonight's live stream. Now, if you're watching live, as always, please feel free to ask questions in the YouTube live chat at any time, and I'll try to keep an eye on that and answer questions as they come up. So here's what I plan to cover. First, I'm going to kind of close out the term by talking about some of the news, orders, and summary opinions that came out of the court over the past week. And there was a number of lower profile kind of small opinions related to orders or summary decisions. And so I'll be talking about each of those. Then I'm just going to take kind of a brief look back at the term as a whole, just a kind of a big picture look at that. And after that, I'm going to move ahead to next term. I'm going to quickly preview the new cases the court granted this week for next term, and there were quite a few of them. The court significantly increased the docket for next year this week. And I'll just take a look at how the next term is shaping up so far. Then I want to talk a little bit about the immediate future, what to expect and what to look for as the court moves into its summer recess. And then finally, we'll finish by spending a few minutes to talk about Justice Anthony Kennedy and his retirement and what's to come there. We'll look back at his career, look ahead at what's coming next for the Supreme Court. So let's get started. First, before I get into the court's business, just a quick milestone. This Saturday, June 23rd, was Clarence Thomas's 70th birthday, and I think this is important to it's a milestone year, but it's important to pay attention to when we're thinking about retirement and Anthony Kennedy, who's 81 years old, leaving the court. Now, at 70 years old, Clarence Thomas is already at an age when many people, especially many government employees, have already retired. In fact, there are at least 5 U.S. states where 70 years old is the mandatory retirement age for judges. But here on this Supreme Court, he's at least until Kennedy's departure at the end of the month or at the end of July, Thomas is only the 4th oldest justice. We've got Justice Ginsburg, who's 85 years old, Kennedy, who's 81 but leaving the court, Breyer, who's 79 years old and turning 80 later this summer. And this is kind of an interesting artifact of just the life tenure and the fact that these judges have these positions for life if they want it. They can stay in the court as long as they want to, and there's really no way to remove them if they are still happy to do the job. And you see this also in the lower federal courts. There's multiple current federal judges serving in the lower courts that are over 90 years old right now. That includes Judge Jack Weinstein, who's a highly influential federal district judge in the Eastern District of New York, who's right now 96 years old, but is still very active. And only about 2 weeks ago, issued an opinion related to qualified immunity that was getting a lot of attention in the legal press. So 96 years old and still very active and still out there. And it's just it's kind of an artifact of this system, the life tenure system, which is extremely unusual. It's more or less unique to the federal judiciary, and it's not something that's seen in general in the state judiciaries or in other countries. So again, Thomas just turned 70 years old. Next in line after Thomas in terms of age is Justice Alito, who's 68 years old. So he's in the middle of the pack on the court. He's still more than a decade away from his octogenarian colleagues. But again, at 68 years old, he's already older than many retired professionals. And it's just kind of a reminder that the longevity of the court's oldest members can kind of skew our perspective on the likelihood that the relatively speaking younger members of the court might choose to retire or might suffer from serious health problems associated with aging that might lead them to have to leave the court, things like that. It's just something to think about. As a final note, there was another birthday this week. Justice Sotomayor also had a birthday and turned 64 on Monday. So she's in the court's younger half, but is herself only a year away from Medicare eligibility. So it's just putting things in perspective on the age of these justices on the court. So let's move on to the court's business. On Monday this week, the court issued its usual order list following last week's private conference. So that order list, it includes a bunch of interesting orders, including grants of 7 new cases for next term, and one opinion relating to an order, which I'll talk about in a few minutes. But this morning, this is Thursday, June 28th, the court, following yesterday's closing out of the term, the issuance of the final opinions in argued cases, this morning the court issued a kind of a final orders list. It's usually referred to as the cleanup orders list. And this is a final set of orders kind of wrapping up various pieces of business before the justices leave town for the summer. But there's also some interesting stuff in here. There's several summary decisions, other opinions related to orders, and the court granted 7 more cases today for next term. So I'm going to kind of talk about a bunch of this stuff. I'll kind of run through the highlights of the orders and opinions from the last week, or from Monday and today this week. Now, first, the orders list, it contains a number of GVRs. Now, I've talked about this a few times before, but GVR stands for grant, vacate, and remand. And this is when there's a petition for the court to hear a case, and the court takes that petition and grants the petition solely for the purpose of wiping out the lower court opinion and immediately sending it back, basically, for a do-over in the lower court. Now, why does the court do this? It's most commonly, it's because the Supreme Court decided a case that changes the legal landscape, and that's related to the case, the petition that's before the court. So the court basically will send the case back to the lower court to let the lower court determine whether the new Supreme Court case changes the results or the analysis in that case. And it can go either way. Sometimes it does. Sometimes the lower court will have to reverse or revise in a major way its opinion that it issued because of the new Supreme Court opinion. Sometimes it doesn't make much difference at all. The lower court may basically reissue its previous opinion essentially unchanged, and the case will end up just popping right back up to the Supreme Court a short time afterward. And just as an example of how this often goes, last Friday, the court decided, among other cases, decided Carpenter v. United States. That was a case about the legality of warrantless access by law enforcement to cell site location data. In today's orders, these cleanup orders, there are 6 different cases that were GVR'd, that's granted, vacated, and remanded in light of Carpenter. So presumably, I haven't looked into these cases, but presumably each of these cases either involves police access to cell site location data, or maybe a closely related topic like access to other digital records held by a third party. So the court's just sending these cases back down because the Carpenter decision may fully resolve those cases, or at least significantly change the legal analysis. Now, I'm mentioning this, usually don't talk much about these GVRs because they're fairly routine and not that interesting, but there's 2 GVRs that are of some interest in Monday's order list this week. One is the case called Rucho v. Common Cause. And this is a case, it's a case out of North Carolina, and it's a political gerrymandering case. Now, as you may remember, this term, the court had two partisan gerrymandering cases on its docket this year. It was Gill v. Whitford out of Wisconsin and Benesek v. Lamone out of Maryland. And the court has been holding this North Carolina case, Rucho v. Common Cause, pending the decision of those other partisan gerrymandering cases. Now, you may recall the court got rid of those two partisan gerrymandering cases without deciding very much about the constitutionality of political gerrymanders. The Maryland case, Benesek v. Lamone, was disposed of basically on procedural grounds without touching the underlying gerrymander issue. And Gill v. Whitford, the Wisconsin case, it was decided on grounds of standing. That is, that the challengers to electoral map weren't the right people with the right kind of legal injury to raise the claims that they had brought. Now, after Gill v. Whitford was decided, the challengers in this North Carolina case filed a supplemental brief with the court arguing that standing problems that the court had found in Gill v. Whitford didn't apply in this North Carolina case. So they said there's no need to remand this case. This case doesn't have those problems that the court found in Gill v. Whitford. So the court should now still hear this case. The state responded to that, arguing the opposite, saying that there was a standing issue. And on Monday this week, the court vacated and remanded that case, the North Carolina case, in light of Gill v. Whitford. Now, just as a technical matter, this isn't technically a GVR, grant, vacate, and remand. It's just a vacate and remand because these election districting cases, gerrymandering cases, and the like, they come to the court on direct appeal. Not on these cert petitions. So they get appealed directly up to the Supreme Court. The court doesn't have a choice of whether to grant these cases or not. So the court doesn't have to grant these cases and vacate and remand. They already have the case on appeal, so they just vacate and remand, and that's that. So that's the one, this North Carolina partisan gerrymandering case. And the other one that was interesting on the same day was a case called Arlene's Flowers v. Washington. Now, this is a case about a florist who refused to make flower arrangements for a same-sex wedding ceremony. And there's obvious similarity to the issue in the case of Masterpiece Cake Shop, the big case about a baker who refused to make a cake for a same-sex wedding celebration. Now, if you may recall that in Masterpiece Cake Shop, the court didn't decide the primary free speech and religious free exercise questions in the case, the questions that the court had granted the case to hear, but instead decided on the basis of a anti-religious hostility on the part of the state's Civil Rights Commission. So kind of sidestepped the main issues that had been presented and decided on these other grounds. Well, the florist in the Arlene's Flowers case filed a supplemental brief after Masterpiece was decided, asking the court to remand the case for consideration by the lower court to consider this anti-religious hostility issue that the court decided in Masterpiece Cake Shop. The state responded that issue, this anti-religious hostility issue, just wasn't really an issue in the case. It wasn't implicated, and there's no reason for the court to remand the case. But on Monday, the court GVR'd that case in light of Masterpiece Cake Shop. So it's interesting because Masterpiece and Gill v. Whitford, they've both been characterized as cases where the court it ended up basically ducking the major issue that was presented to it and getting rid of the case on other grounds. Now, the North Carolina gerrymandering case and the Arlene's Flowers cases, they looked like they could be potential vehicles for the court to take another crack at each of these subjects. They looked like, the court found reasons why Masterpiece and Gill weren't the right cases. Well, here's another set of cases with the same issues. Maybe these are the right cases. But the court vacated and remanded suggests, maybe one of the explanation is just there's really no appetite on the court to take on these topics right now. And the court was happy to duck these cases and happy to have an excuse to get them back off its docket again. But that's likely only to be a temporary thing. Both of these cases are likely to make their way back before the court relatively soon, just with a detour back in the lower courts first. So just an interesting thing to notice. Now, another interesting thing, this was on today's orders list. There was a summary affirmance of a case called Harris v. Cooper. Now, this is another, it's another election districting case. And as I mentioned, these come up on direct appeal to the Supreme Court. And so the Supreme Court doesn't have a choice whether to, the court can't just deny these cases and choose not to hear them. They have to decide the cases. The court does not, however, have to issue an opinion. And what happened here is this case came up to the Supreme Court, and the court issued a summary affirmance, so just a one-line order just saying that this case was affirmed. Now, what is this case? Well, it's a challenge to North Carolina congressional districts, challenging them as partisan gerrymanders. So it's a very close case to that Rucho v. Common Cause case that the court just vacated and remanded. But in this case, what happened below was the district court below rejected the partisan gerrymandering challenge under both an equal protection theory and a First Amendment theory. Said that there was basically no discernible standards that the court could use to determine whether there was unconstitutional partisan gerrymandering. And the appeal was taken to the Supreme Court. Now, the Supreme Court just issued this summary affirmance. There was no opinion. There were no noted dissents. What does this mean? Well, technically it means the court agrees with the lower court's results. So the outcome of the lower court's case it agrees with, but it doesn't necessarily endorse the reasoning and the opinion of the lower courts. It's saying, oh, the lower court got it right, but it isn't expressing an opinion one way or the other on whether the actual legal reasoning in the lower court's case was right. But what does this all mean? It seems kind of odd in light of that vacate and remand in the Russo case only a few days earlier. So there's a question about whether, you know, the lower courts will read this this affirmance, this summary affirmance, as kind of saying, you know, indicating something more about the court's views on whether these are whether these are claims that the courts can even hear. But it's kind of an odd development. You know, no opinion attached to it, so a little hard to read the tea leaves on what that's supposed to mean. Now, another order issued this week was related to another death penalty stay application. And again, this is a regular part of the court's business. I've talked about these off and on numerous times in these weekly live streams. There hasn't been one for a few weeks, but there was an execution scheduled for yesterday. And this was the convicted inmate was named Danny Bible, and he was in Texas death row, and he had been convicted for a 1979 rape and murder of a young woman with an ice pick, and he had been dubbed by the media the ice pick killer because of this. Now later he committed multiple additional rapes and murdered several other people, including an infant. So he had quite an ugly criminal history here. But the stay application to the Supreme Court was based on an Eighth Amendment cruel and unusual punishment challenge, and the facts as alleged in his stay application were that he's getting older. He's 66 years old at present, and suffers from an array of health problems. Here's how they were described in the stay application. It said he suffers from heart failure, coronary artery disease, peripheral artery disease, chronic venous insufficiency, poor circulation, Parkinson's disease, chronic obstructive pulmonary disease, obstructive sleep apnea, paralysis, gastroesophageal reflux disease, hypertension, hyperlipidemia, diabetes, and a blood clotting disorder. Now, apparently, supposedly, as a result of all these various health problems, he had severely compromised veins, and the allegation was that it would be unlikely that the personnel conducting the execution would be able to establish an IV for the lethal injection. And the argument was that in his specific, due to his specific medical characteristics, lethal injection would be a cruel and unusual punishment as applied to him. And he had argued that the state should have to use some alternative to lethal injection. And the state had responded that lethal injection was the only approved method of execution, and they had contested his factual claims. Yesterday, the Supreme Court denied this stay application. There was no noted dissents and no opinion. And last night he was executed. Apparently, there were no apparent complications with the execution, and the execution went ahead last night. One more interesting development in a case that I'd like to discuss. And this is a case I discussed this last week on last week's live stream. And this is a case of Sessions v. City of Chicago. And this is litigation about the Trump administration's sanctuary city policies, so-called. And what had happened is in the court in this case had issued a nationwide injunction barring the Trump administration from implementing this policy. Now, the party in this case was the city of Chicago, but the injunction was barring the federal government from applying this policy nationwide. Now, the government had made an application to the Supreme Court for a stay of this application, not with respect to the city of Chicago, but with respect to every place outside of Chicago, arguing basically that it was improper for the court to have its injunction apply beyond the actual parties to the case. Now, what had happened is earlier, Justice Kagan, who was the circuit justice assigned to the particular geographical region, this is the Seventh Circuit Court of Appeals region, Justice Kagan had ordered a response from the city to be filed by yesterday. However, on Tuesday, after the Trump v. Hawaii decision was issued, that's the travel ban litigation, that decision included a concurrence by Justice Thomas that was criticizing the increasing use of these nationwide or universal injunctions. And after that opinion was issued, the Court of Appeals below modified the injunction in this city of Chicago case so that it only applied to Chicago and it no longer applied. I apologize for the technical difficulties there. My feed cut out briefly. I hope you're still with me. But I was saying that the Court of Appeals modified the injunction so it only applied to the city of Chicago. And after that happened yesterday, the Attorney General Sessions filed a letter with the Supreme Court withdrawing the application for a stay. It was no longer necessary now that the injunction had been modified. So that was just an interesting development in that case. I had flagged that case last week, and now that issue has gone away there. So let's move on to some opinions. As I mentioned in previous episodes, I've already talked about all of the the opinions in argued cases, the big cases on the court's docket. But this week there were a few, there were several opinions related to orders. So this is opinions the justices write when they want to express some disagreement or comment on one of these orders that the court is issuing, and a few summary decisions where the court decides a case without any extra briefing or oral argument. So I'm going to kind of briefly run through each of these. Now, on Monday, there's a case called Peed v. Jones, and Justice Sotomayor issued a statement respecting the denial of the petition. And that was joined by Justice Ginsburg. Now, a statement respecting denial is when a justice isn't dissenting, so they're not disagreeing with the court's decision not to take a case, but they feel that there's something more needs to be said about the particular case. Now, this was a habeas corpus case. Specifically, it was a challenge alleging the ineffective assistance of counsel by a failure to present mitigating evidence at trial. And the 11th Circuit Court of Appeals had rejected this claim, saying that there was no prejudice. Now, an ineffective assistance of counsel claim, one of the things that has to be proven is that the criminal defendant was actually prejudiced. That means things would have come out differently had the attorney performed effectively, performed at a proper level of competence. And the 11th Circuit says here he failed to show that he was prejudiced. He failed to show that things would have happened differently. And part of the reason was that the mitigating evidence that he says should have been presented was what the 11th Circuit characterized as a double-edged sword. It had aspects that could have helped him, but aspects that also may have hurt him and made the jury regard him as in some way more culpable. Now, Justice Sotomayor argues, she says that this double-edged sword rule that the 11th Circuit applies actually contradicts Supreme Court precedent, and it doesn't follow the court's rulings that you need to consider the totality of the evidence when considering the effect of mitigating evidence. But she suggests that review of this case is actually barred by a law called the Anti-Terrorism and Effective Death Penalty Act. She says here, Here's a quote. She says, "Considering the posture of this case, under which our review is constrained by the Anti-Terrorism and Effective Death Penalty Act of 1996, I cannot conclude the particular circumstances here warrant this court's intervention." Now, the Anti-Terrorism and Effective Death Penalty Act is referred to as in short as AEDPA, or EDPA for short. That's kind of the short version of that. The legal standard in that is that in order to overturn a state court's determination, the federal court in these habeas proceedings has to find that there was an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. And so Sotomayor seems to be suggesting that that this case doesn't meet that standard, that it wouldn't meet the standard of violating clearly established federal law as determined by the Supreme Court. It's a little odd to me, because she suggested earlier in this short opinion that the rule applied by the 11th Circuit actually contradicted Supreme Court precedent. So it seemed like she was suggesting otherwise, but that's that opinion. So moving on, I'm moving on to some orders that came down on Thursday, and one was in a case called E.I. DuPont de Nemours and Co. v. Smiley. And this was a statement respecting denial by Justice Gorsuch, joined by Chief Justice Roberts and Justice Thomas. So again, this is a statement respecting the denial of a petition. It's not a dissent, but just an additional comment relating to it. Now, this is a case about courts giving deference to a federal agency, a position taken by that federal agency for the first time during the course of litigation. And there are various deference doctrines in administrative law, and these are rules about the way courts are supposed to defer to certain determinations by administrative agencies about what particular laws or regulations, how those laws or regulations should be interpreted, what they should be interpreted to mean. And this case is about one particular type of deference that's referred to as Skidmore deference. And that's basically the weakest form of deference. And it's often regarded as not really, deference at all, but just common sense. It basically tells courts to weigh the agency's interpretation based on a consideration of the reasoning involved, the level of expertise, and various other factors. But Justice Gorsuch says here, and this is some quotes from his opinion. He says, quote, "Skidmore deference only makes a difference when the court would not otherwise reach the same interpretation as the agency." So he's saying here, even if this is a weakest form of deference, if it means anything, it has to make a difference sometime. And he asks a number of questions, and his specific concern here is when an agency during the course of litigation asserts an interpretation of a rule and then demands deference from the court in adopting that interpretation. And so Gorsuch basically asks a number of kind of rhetorical questions about this. He says, first, how are people to know if their conduct is permissible when they act if the agency will only tell them later during litigation? Don't serious equal protection concerns arise when an agency advances an interpretation only in litigation with full view of who would benefit and who would be harmed? Might the practice undermine the Administrative Procedure Act's structure by incentivizing agencies to regulate by amicus brief rather than by rule? And should we be concerned that some agencies have apparently become particularly aggressive in attempting to mold statutory interpretation and establish policy by filing friend of the court briefs in private litigation? And he says that there's a clear circuit split. That's a divide between different courts of appeals on this issue, on whether deference should be given in these situations, and concludes saying, "I believe this circuit split and these questions warrant this court's attention, if not in this case, then hopefully soon." Now, it's interesting again, because this is a statement respecting the denial. It's not framed as a dissent. He doesn't say he's disagreeing with the decision not to take this case, but he doesn't explain anywhere why he doesn't dissent, why if there is some reason that he agrees that this isn't the right case to answer that question. So that's just a little mystery there that isn't answered there. So moving on to the next case, this is a case called Rowan County v. Lund. And here, this is a dissent from the denial of a case by Justice Thomas, joined by Justice Gorsuch. Now, this is an Establishment Clause challenge to a county board of commissioners practice of having commissioner-led prayers at the beginning of their public meetings. And Justice Thomas says that there's a circuit split about these legislator-led prayers. And but he argues, he cites kind of a long tradition in the United States of these type of legislator-led prayers, points to the circuit split, and he kind of opened up the decision by saying, quote, "This court's Establishment Clause jurisprudence is in disarray." And he concludes by saying this court should have stepped in to resolve this conflict. So he says there's basically a circuit split there. He kind of indicates that he thinks that his view is that these legislator-led prayers are under the court's cases and the long tradition. These are should be allowed, but he notes that there's a circuit split and courts have come out in different ways on this. So that brings me to the next case. This is a case called Kaushal v. Indiana. And this is a dissent from denial by, I'm sorry, this is an unusual case. This is a dissent from a GVR, a dissent from the decision to grant, vacate, and remand a case. It's written by Justice Alito, joined by Justice Thomas. Now, this particular case, this Kaushal v. Indiana case, was GVR'd in light of a case called J. Lee v. United States. Now, that case, that J. Lee case, was a case about ineffective assistance of counsel with respect to taking a guilty plea. But Alito says here, the problem here is the lower court here, the Indiana Court of Appeals decision, came a month after the Supreme Court had issued its J. Lee decision. So the Supreme Court had already issued its opinion in this J. Lee case before the Indiana court decided this case. Apparently, this J. Lee case was actually argued to the court below, and so it was a case that was already before this Indiana court. And so Alito basically says this is an inappropriate use of the GVR. The GVR process, this grant, vacate, and remand, is supposed to be when there's been some intervening change of law between when a case was decided by the lower court and when it gets up to the Supreme Court. There's been some change of law, so the court sends it back to give the court another chance to do it. But here he says there was no change. The Supreme Court's precedent was already on the books before the Indiana court did this. So presumably, if it was wrong and should be overturned as wrong, then that's one thing. But it shouldn't just be sent back as a do-over. That's not the way the court is supposed to do these things. So that's that case. And then the final one here is it's two consolidated cases, Jordan v. Mississippi and Evans v. Mississippi. And this is a dissent from the denial of these cases by Justice Breyer. And these are challenges. This is part of a theme Justice Breyer has been pushing for a couple years now in a number of opinions, challenging the death penalties overall as cruel and unusual punishment due to the manner of its implementation in the United States. And so he points to a few different things. A few things he's noted before. That one is the extensive period of delay between a sentence of death and the actual execution. And Breyer has argued that this delay in itself makes it cruel and unusual. Leaving someone on death row and in this kind of precarious position for such a lengthy period of time is cruel and inhumane. And in this particular case, one of the criminal defendants here, Jordan, is currently 72 years old, but has been on death row for 42 years. Well over half his life has been spent on death row, 42 years. And Breyer kind of describes the isolated condition of death row and argues that this is maybe cruel and unusual punishment. He also brings another thing he's discussed in previous opinions is the geographic arbitrariness of the application of capital sentences. And he notes that increasingly, especially as the number of death sentences that are put into effect each year has continued to dwindle, and it's reached historic lows in recent years. The actual death, both death sentences that are imposed and the actual executions that are carried out are increasingly concentrated in a very small number of counties in a relatively small number of states. And he says that this kind of arbitrariness, where just the fact of which county someone is convicted in is more determinative than other factors that relate to the actual culpability or severity of the crime. That this is another factor that he has he has cited as leading to the conclusion that it's cruel and unusual punishment. And he concludes by just another point that's not directly connected to these particular cases, but he talks about the unreliability of the capital punishment process, and he points to some certain recent death row exonerations, including one case where apparently the death sentence was stayed only 4 hours before execution. And he concludes by saying, I remain of the view that the court should grant the petitions now before us to consider whether the death penalty as currently administered violates the Constitution's 8th Amendment. So those are the opinions related to orders. I'm going to move on now and talk about, there was 3 summary opinions that came down this morning, Thursday morning. One is a case called Sos v. Bauer. This is a kind of a just an odd little case. So these are summary reversals. These are cases where the court has basically decided to reverse the decisions below without requiring full briefing and oral argument. So they've decided that there's a clear enough error below, and it's worth their time and effort to just reverse these cases, but without taking them up as a full case on its docket. Now, this is a case where about a civil rights claim brought against police officers and the mayor of a town. And it relates to alleged harassing behavior by the police. And the particular incident that's being complained of here is an incident where the police came into this woman's home, and when she attempted to kneel and pray, they ordered her to stop. And she brought a free exercise claim, that they were abridging her free exercise of religion by stopping her from praying. Now, the lower court threw this case out. They said there was qualified immunity, which just means that the police were not in violation of clearly established law, that there wasn't clearly established law, so there weren't like cases that directly showed that this was a violation of her rights. Now, the court doesn't, in those cases, in a qualified immunity case like that, the court typically doesn't decide whether there actually is a constitutional violation, just that the violation is not clearly established. Now, the court notes, what the court says here is that, in fact, whether a police order interfering with prayer is acceptable or violates some constitutional right depends on the specific circumstances involved. And they say that here, those specific circumstances are just unknown at this point. And here's a kind of a long quote from the opinion. It says, quote, as the case comes before us, it is unclear whether the police officers were in petitioner's apartment at the time in question based on her consent, whether they had some other ground consistent with the 4th Amendment for entering and remaining there, or whether their entry or continued presence was unlawful. Petitioner's complaint contains no express allegations on these matters, nor does her complaint state what, if anything, the officers wanted her to do at the time when she was allegedly told to stop praying. Without knowing the answers to these questions, it is impossible to analyze petitioner's free exercise claim. But what the court says here is, this was a pro se complaint, meaning this was someone who was not represented by an attorney who brought this complaint. And the court says pro se complaints have to be interpreted liberally. The court says this free exercise claim, it requires consideration of the circumstances of the officer's presence there. And so the court remands this back to the lower court for further proceedings, basically to explore the circumstances surrounding this, which the court says are necessary for determining the constitutional issue here. So moving on to the next case, a case called Sexton v. Boudreau. And this is a habeas corpus case, an ineffective assistance of counsel claim. And the court here says basically the federal court failed to give proper deference to a state court's determination that there was no ineffective assistance of counsel. And the underlying issue here was, in the case, there were eyewitnesses that identified a shooter in a murder prosecution. They identified the shooter based on photographs. And the argument that was made was that the failure of the attorney to challenge the proceeding, the procedure of showing these photographs as a suggestive procedure, was ineffective assistance of counsel. Now, the state court here rejected that claim, but it was a summary denial, meaning the state court just rejected it, but without a reasoned opinion explaining why they were rejecting it. The Ninth Circuit Court of Appeals in the federal system overturned that, saying that, in fact, it was ineffective assistance of counsel. Now, the court says basically here, this is reviewed, these habeas corpus cases, under that AEDPA standard that I mentioned a little earlier here, where it's a highly deferential standard where the state courts can only be overturned if it was something that was contrary to or an unreasonable application of clearly established federal law. That's the basic standard. Or moreover, where you have a situation like this where there's no reasoned decision. So this is where it was a summary decision with no opinion explaining it. The federal court, quote, must determine what arguments or theories could have supported the state court's decision, and then it must ask whether it is possible fair-minded jurors could disagree that those arguments or theories are inconsistent with the holding in a prior decision of this court. So there's this highly deferential standard where the court is supposed to try and figure out if there is some viable argument or theory that would satisfy the standard of not being inconsistent with the Supreme Court. And the argument here was the court basically says that given the details and facts of this eyewitness identification procedure, that it could have been determined that the counsel in the case below, the counsel that did not challenge these eyewitness identification procedures, could have reasonably determined that a motion to suppress the eyewitness identifications would have failed because under the totality of the circumstances, the identification was reliable. And the court kind of recites various circumstances of the identification that would support a finding of reliability. But in doing this, the Supreme Court kind of slaps down the Ninth Circuit a little bit. It says, quote, the Ninth Circuit's opinion was not just wrong, it also committed fundamental errors that this court has repeatedly admonished courts to avoid. That could support the state's decision and failed to give proper deference to the state court. So just overturning that Ninth Circuit decision and allowing the state court's determination that there was no ineffective assistance of counsel, allowing that decision to stand. Now, Justice Breyer dissented without an opinion from this. So just a one-line dissent saying he dissents from this. That's somewhat unusual in these summary decisions to dissent without any opinion, but it does happen from time to time. And then the final of these summary decisions is a case called North Carolina v. Covington. And this is a racial gerrymandering case. And it's been up to the Supreme Court before. And in previous visits to the Supreme Court, the court had, the lower courts had found that there was racial gerrymandering, and that had been affirmed by the Supreme Court. And the issue here is the remedial issue, meaning how to get new maps in place to fix the racial gerrymandering problem. Now, what happened is the lower court here had identified two separate problems. There were 4 districts where voters had been segregated on the basis of race. So it's just a racial gerrymandering problem in those 4 districts. Now, there were also 5 districts where there was an argument that those districts in this whole process of redrawing the maps to solve certain racial gerrymandering issues, 5 districts had been unnecessarily redrawn. And this, what happened is there's a state rule in North Carolina that prohibits mid-decade redistricting. And part of the purpose is just to prevent the parties in power from just continually redrawing lines every couple of years just to try and keep giving themselves an advantage going forward. So the rule is basically you redraw the districts after the census every 10 years, and then you're supposed to leave them alone in between until the next census. And so 5 districts were redrawn when there was no need to do so. So this violated this state prohibition. Now, what the lower court had done was it appointed a special master to draw up a new map. It determined that these challenges to the legislature's map, to the challenges to the 4 districts that were challenged as racial gerrymanders and the 5 districts that were challenged as violating the mid-decade redistricting, it said that those were valid challenges, and it approved the special master's map that fixed the problems in these various districts. Now, what the Supreme Court says is it affirms the district court with respect to the racially gerrymandered district. It says, yes, we affirm the decision of the district court below to approve the special master's redrawing of these racially gerrymandered districts. But it reverses as far as the mid-decade redistricting. And it's basically saying there isn't any federal claim here, and there's nothing the federal court should be involved in. The issue of whether the state legislature, by redrawing parts of a map mid-decade, was violating state law, that's a state law issue, and that's that's not an issue for the federal court to deal with. Now, Justice Thomas issued a very short dissent in this case, so it's a per curiam unsigned opinion, a summary decision, except for Justice Thomas has a short dissent, and he just simply says, quote, I do not think the complicated factual and legal issues in this case should be disposed of summarily. I would have set this case for briefing and oral argument. So he doesn't think this was appropriate for summary disposition like this. So that kind of wraps up all of the orders and significant orders and these opinions for the term. It gets us to the end of the term's opinions. The theme of this year was there were a ton of big high profile cases this year, way more than usual. There was, depending on how you count, there was maybe 9, 10, 11, 12, depending on what you count as significant, but a very large number of cases that were just either very high profile, lots of media attention, very divisive, those type of cases. Now, a few of those cases ended up being kind of fizzles at the end. Masterpiece Cake Shop, the Parson gerrymandering cases. But the general theme for a lot of these high-profile cases was this was a big year for victories by the conservative wing of the Supreme Court. There were an unusual number of 5-4 splits along that ideological conservative liberal line, much more than usual, and that kind of coincided with this high number of very high profile cases, leading to a year where there's this kind of an especially lopsided result toward the conservative victories in the case. Now, it wasn't a complete rout in all of the court's cases, but a very high number of the most high profile cases went toward the conservative wing of the court this year. So that's kind of just a real brief theme overall. I want to now kind of pivot and look ahead to next term. I mentioned, I think before, that there were, between Monday morning's orders list and the orders issued this morning, there were 7 new grants on Monday and 7 this morning. That's 14 new cases granted this week, so quite a few. And that brings the total up to 37 cases granted so far for next term. Now, I've mentioned this in the past, but basically, in order to the court has to grant enough cases by the time it leaves at the end of June to fill up its fall calendar, just for purposes of timing, to have enough time to have cases be fully briefed for oral argument. The cases have to be granted by now in order to make it onto the fall calendar, meaning the October, November, December argument calendars. Now, to fully fill those fall calendars, the court basically needs about 34 cases. And what this basically means is the court hears argument 7 months of the year, so October through April, and each month it hears 2 weeks of argument, and each week that it hears it sits for 3 days. And the court typically likes to hear 2 arguments per argument day. Now, if you do the math out from there, that would be that would result in 84 cases of 42 days of argument. But in fact, there's a few holidays in there, so there's really only about 39 days of argument for the whole term. So about 78 arguments would fill the calendar for the court for a year. And of those argument days, there's 17 argument days in October, November, and December. One holiday, so not 18, but 17 days. So 34 cases would fill up the fall calendar. Now, in the past several years, the court has had a light fall calendar, less than 34 cases. It hasn't had enough cases granted by the end of the term to fill up that fall calendar. And this has resulted in the court kind of trying to bulk up its calendar in the spring and having a much heavier spring calendar. And this contributes to the backloading of the court's term, where it kind of exacerbates the crunch that the court has every year in June as it tries to get all of its opinions finished and issued before it leaves for the summer. A few years back, in an attempt to kind of alleviate this backloading problem, the court had made some small attempts to front load the term a little more. That it had added some additional arguments in the fall, having some 3 argument days instead of 2 argument days to kind of load up the front of the term, presumably in hopes that this would allow it to lighten its load later in the term and get things done more easily, space out their work a little more so they weren't so crunched at the end of the term. But this kind of fell apart when the court's caseload continued to drop, and it ended up not having enough cases to fill up the fall term. Now that it actually has again, so this is the first time in several years that it has enough cases granted to fill up the fall term. It wouldn't be surprising if it decides to fit a few more than 34 cases, and it has 37 cases. It could put all 37 of those cases in the fall calendars to get a few more cases decided earlier on, but that remains to be seen. Typically, the October calendar will come out sometime in mid-July, So we don't know exactly which cases will be up on the October calendar yet. And then the November calendar won't come out until later in the summer sometime. So really quickly, I'm going to just give a brief, 1 or 2 sentences about each of these 14 cases, the new granted cases for next term. And just very, very quickly, I'm just kind of rush through these because there's just to keep things moving. There's 2 cases that are kind of related to civil procedure type issues. One is called Republic of Sudan v. Harrison. And this is a case about the proper way to serve a lawsuit on a foreign state. So if you're suing some foreign country, in this case, the Republic of Sudan, how do you serve them with your lawsuit? So it's just an odd, unusual kind of situation. And the other case is called Nutraceutical Corp v. Lambert. And this is a case about deadlines, and specifically it's a deadline to appeal a grant or denial of class certification. This is in a class action, the determination of whether the court is going to allow it to go forward as a class action. And the question is that deadline, can the court grant exceptions to that deadline? Can the court grant equitable exceptions and say there's reason to allow that deadline to be extended or not? There's also an arbitration case, another arbitration. The court already has a few arbitration cases that it granted earlier, but there's another arbitration case that it granted this week called Henry Schein Inc. v. Archer and White Sales Inc. And this is asking whether there's an exception to the enforcement of arbitration provisions where the claim of arbitrability is wholly groundless. Now, the idea here is normally in order to arbitrate, if parties have an agreement with an arbitration provision, the rule, and there's a question about whether the particular dispute is actually arbitrable under that arbitration provision, that decision of whether it should be arbitrable actually goes to the arbitrator to decide in the first instance. And here the question is, if this claim that this dispute should be arbitrated is wholly groundless, is that an exception? And can the court just decide that and not have to send it to an arbitrator first? Now, the court has added 2 more cases, Indian law cases, and it already has at least one other Indian law case on its docket this year, but it added 2 more that are both related to some treaty issues. And one is called Washington State Department of Licensing v. Cougar Den, Inc. And it asks whether an 1855 treaty gives the Yakima Nation Indians the right to avoid certain state taxes for off-reservation activities. And then another case called Herrera v. Wyoming asks whether an 1868 treaty protects the Crow Indians' right to hunt on certain federal forest land. So those are the Indian law cases coming up. And then there's a sovereign immunity case. This is a case called Franchise Tax Board of California v. Hyatt. Now, sovereign immunity is the idea that sovereign bodies, governments, are in some circumstances immune from being brought into court. They're immune from lawsuit. And this is specifically as a challenge to a previous Supreme Court decision called Nevada v. Hall that held that a U.S. state is not immune from a lawsuit in the courts of another state. And this is a case asking the court to overturn that and find that states are immune from being sued in the courts of another U.S. state. There's a tax law case called Dawson v. Steger, and this is asking under a particular federal statute whether a state is permitted to give tax exemptions for state law enforcement personnel's retirement benefits without giving a corresponding tax exemption for the retirement benefits of federal law enforcement agents. There's a Social Security case. This is related to a specific case about evidentiary issues in Social Security disability proceedings. It's called Beastech v. Berryhill, and it asks whether an expert witness in a Social Security disability proceeding has to provide evidence to back up the testimony given in those proceedings. There's a couple of intellectual property cases added this week. One patent law case called Helsin Healthcare v. Teva Pharmaceuticals. And this asks whether a sale to a third party made under a confidentiality agreement constitutes prior art. So if before obtaining a patent on some invention, the inventor sells that product to some third party, but it's kept out of the public, is that prior art that would actually invalidate their attempt to later get a patent on that invention? And then there's a copyright question, and it's a very technical dispute. It's called Fourth Estate Public Benefit Corp v. wallstreet.com. And this one asks what is the effective date of a copyright registration? Is the effective date of that when the application was delivered to the Copyright Office, or is it not until the Copyright Office actually acts on the application? Moving on, there's one criminal law case about double jeopardy, the protection against double jeopardy. This is Gamble v. United States. And this is a challenge to something known as the dual sovereign doctrine. And that's the idea that in the United States, the American system, a trial on a criminal charge by one sovereign, so say the federal government or the government of one of the states, doesn't prevent a later trial on the same conduct by a different sovereign. So if someone is tried in state court, and whether they're convicted or acquitted, they can be tried again for the same conduct in federal court afterward. That's called the dual sovereign doctrine. And this is a challenge to that, saying that should be overruled and that double jeopardy should apply to prevent a second trial. There's a case about civil rights actions called Neves v. Bartlett. And this is a case that asks whether probable cause defeats a claim, a claim brought for a retaliatory arrest. Now, this is interesting because it looks like it's the issue that the court touched on this in a case called Lozman v. City of Riviera Beach this year, where the court decided on a very, very narrow grounds that didn't that kind of left a lot of questions open about how broadly that would apply. And this looks like another case that's going to explore that same question further. I haven't looked into it in any detail, but it appears to be what that case is about. Then there's a case about the Fair Debt Collection Practices Act, a federal law that imposes certain requirements and restrictions on debt collectors. And the case is called Obdusky v. McCarthy and Holthus LLP. And it asks whether the Fair Debt Collection Practices Act applies to non-judicial foreclosure proceedings. And I'll just be honest, I have no idea what that's specifically about. I don't know what that refers to or anything about that case at this point. So move on from there. There's one case about preemption, and preemption is the idea that federal law under the Supremacy Clause of the U.S. Constitution, federal law can preempt state law. That is, it prevents the state law from having any effect because the federal law is supreme over the state law. And in this case, it's called Merck, Sharp, and Dome Corp v. Albrecht. It asks whether state law failure to warn claims, so that's a type of tort law claim where it's imposing liability for a failure to warn about certain dangers of a product, whether these state law failure to warn claims are preempted when the Food and Drug Administration rejected a drug manufacturer's proposal to warn about the risk. So the FDA rejects a proposal to warn about the risk, can someone nevertheless bring a state law claim about failure to warn on that risk? So that's how that case is framed. So that's the 14 new cases the court added this week. And there's a number of interesting legal questions on the court's docket, but really at this point, there are no obvious high-profile blockbuster cases so far. And this is very different from last term, where already on the October calendar, there were quite a few of the big cases that were really being closely watched. And so far, looking not just at these 14 cases, but the entire 37 cases granted for next term, there's really no big culture war cases out there yet. There's no big partisan politics cases pitting Democratic versus Republican interests in some very strong way. There's a lot of kind of narrower, smaller cases. It's a big change from what we saw this term. It's just kind of it's interesting. It's always, when you're looking at the Supreme Court from term to term, you're dealing with fairly small sample sizes. And there's always a question of how much of the change, the difference from year to year, is due to conscious actions or by the justices in making certain decisions, and how much of it is just a result of kind of random variation in the types of things that are being presented to the court and where they are actually seeing major divisions in the lower courts. But it just seems that it's a radical shift from what we saw this year, the highly contentious things, to next year. And maybe that's, to some degree, it's a deliberate attempt by some justices to dial down the level of disagreement somewhat, to try and kind of rein things in from the highly contentious finish to this term, where they ended in the final week with 6 opinions, all breaking 5-4, and most of those 5 out of the 6 breaking along conservative liberal stereotypical lines. So maybe this is a conscious effort by some of the justices to look for some less hot button cases to fill up next term, but maybe not. Hard to say. So what comes next from here? The court is done for the term for now, but in July, at some point in July, the court typically will announce dates for summer orders lists. So a few dates in July where the court intends to issue summer orders lists. Now, these are typically not very interesting. It's usually very routine matters. It's denials of petitions for rehearing, which are virtually denied at basically 100%. Some attorney discipline notices, which are very automatic things at the Supreme Court and not of a lot of interest. So it's very routine. But on rare occasions, it's occasional but rare, the court issues summer grants where it'll actually grant new cases over the summer. Last year, the court granted one case in its late August order list and just added another case to its calendar there. It seems less likely this year, given that there's already a pretty full fall calendar. So the justices probably don't feel the need to, get more cases on the list right away. But you never know. Now, throughout the summer, the court will respond to various emergency stay applications. This will include more death penalty stay applications as they come up over the summer, but also stay applications in other lower court litigation where a party is seeking to stay a lower court judgment from taking effect. And so the court rules on those as they come across during the summer. But that's about it for the rest of the summer. Now, as I mentioned, sometime in mid-July, probably the October argument calendar will come out, and the court tends to schedule the cases roughly in the order they were granted. So the earliest granted cases would typically be on the earliest calendar, roughly. But first of all, it's very common, especially when there's a lot of time between when a case is granted and when it's going to be argued. So there's plenty of time for the briefing schedule. It's very common for the court to grant extensions to the briefing schedule. And this is routine for early spring grants. So these cases that are on next year's calendar that were granted back in say February, most of those cases probably got some extensions to their briefing schedule. So the dates on which all these cases become fully briefed, when all the briefing is done, doesn't exactly line up with the order in which they were granted, but it's as a rough idea. The order in which they're granted is a rough idea of when these cases will be slotted into the argument calendar. But another exception is the court likes to, when it can, to group related cases together on the same day of argument when possible. So you'll see a lot of times when the argument calendar comes out, in a particular day, there'll be two criminal cases or even two criminal cases on related subjects on the same day, or two immigration cases on a day, or two Indian law cases on the same day. So, that's, again, not a hard and fast rule, but the court likes to do that. So see that. But there's no way of knowing exactly when any particular case will be scheduled until that calendar actually comes out, which again will be mid-July. And once that comes out, we'll start to get an idea of how the court's going to approach this. Do they add some 3 argument days to kind of bulk up the fall calendar? Is that something that they try to do or not? So we'll start to have a sense of that when the October calendar comes out. Now, when does the court come back? The court returns on the last Monday in September. So the court's oral arguments always start on the first Monday in October. That's their first day, unless there's in some cases there's been holidays. For example, Jewish high holidays have fallen on the first Monday in October, and so the court has a holiday day or whatever. But normally the first Monday in October is the first day of the court's October oral arguments, and that's the start of the court's new term. But the court returns a week earlier on the last Monday in September and has what's known as the long conference. And this is a special conference where the court is considering all of the cert petitions that have accumulated over the course of the summer where the court has been off. And this is in excess of 1,000 cert petitions, given the current numbers of cert petitions that the court gets in recent years. So in excess of 1,000 cert petitions, the court will consider at that conference. Now, they don't actually discuss or consider the vast majority of those. They circulate lists ahead of time of the petitions that justices think are worthy of considering, and some subset of those that any of the justices have indicated are worth talking about are the ones that will actually get discussed at that conference. But as a result of that long conference, a few days later, the court will issue grants coming out of that. And typically those cases will start getting slotted in to fill the January calendar and beyond, to fill up the later part of the court's term. Now, the grants from the long conference is typically, it's the single biggest grant day of the entire term. The court grants more cases on that day than it does at any other point in the term. But if you look at it in terms of the kind of the percentage chance of getting a grant based on the number of petitions that are being reviewed, it's actually extremely low. The court sees so many, considers so many petitions, all of the petitions that have accumulated over the entire summer, that even the large number of grants that it hands down, maybe a dozen grants or maybe more after the long conference, is still a very, very low percentage out of all the petitions that were up for consideration. So that's what we'll see at the end of September, just before the oral arguments kick off at the beginning of October. One interesting question is, why does the court take a summer recess at all? The lower courts, the lower federal courts, and most of the state courts don't do that. They continue to hear cases all year round, and because of that, they can continue issuing opinions all year round. The cases are coming up to the Supreme Court all year round. So why do they do it? Well, part of it's tradition, part of it's just because they can. The justices enjoy having the time off. They enjoy traveling, teaching classes, things like that. There's a quote that I came across, and I wish I tried to find it, but I couldn't, and I wish I could get the exact quote or identify which justice said it. But there was a quote from a justice, this was back from the early 20th century, who said something, and this is a rough paraphrase, but something to the effect of, the court is able to do 12 months work in 10, but we can't do it in 12. And it was just the idea that there's burnout involved, and the need for some break in order for the court to operate at full efficiency. And some have pointed also to the way the court breaks its work up into terms like this. Has the beneficial effect of imposing a deadline on the court to get its work done. And the court is very good about getting all of its opinions issued by the end of June every year. And that's not always the case in many lower courts. In some lower courts, certain cases, especially particularly tricky or difficult cases, can sometimes be sat on for extended periods of time. And litigants are familiar with this situation, and lawyers who litigate in state courts or lower federal courts are familiar with having argument or having a fully briefed case and just waiting for months and months on end, and sometimes years in extreme cases, before ever getting a decision. And the Supreme Court doesn't have that issue. But the trade-off there is the argument that the court's work is very rushed and of somewhat lower quality at the end of the term in June, because they're just rushing to try and get everything done so they can get out the door. But another benefit people have mentioned about this time off of the summer for the Supreme Court is that it's kind of a cooling off period. There's because of the way the court's work is structured, there's a high proportion of the most contentious and divisive cases end up getting issued in late June. Those cases are some of the cases that take the most time and take the longest to get in final form because of all of the back and forth and between the competing opinions. And so there's a higher proportion of these highly contentious cases at the end of the term. And having a few months off at the end of the term can kind of give the justices time to basically just reset and give time for tempers to cool. And that may be very important for a very collegial institution where some of the members will work together for decades. So that's just another possible benefit for structuring the court's work as it is. But again, the court, for the most part, controls its own schedule, and why do they do it? Because they can is probably the best explanation. So I'm going to conclude tonight by just talking a little bit about Justice Kennedy. So yesterday he issued a letter announcing his retirement effective the end of July. And this wasn't unexpected. There's been talk about a retirement, Kennedy potentially retiring. It's been speculation about it for a few years, but he's been very close-lipped about it. It's not clear that anyone necessarily beyond Justice Kennedy himself necessarily knew that this was coming until it came out yesterday. Even it's possible, though I don't know that anyone knows for sure at this point. It's possible that even his colleagues on the court were not aware that he had made the decision to officially retire this year until he made the official announcement yesterday. Now maybe that's wrong, and maybe they did know, and everyone just kept close-lipped about it. We don't know for sure. The court has a reputation of being relatively leak-free, especially compared to the other branches of government, and there's not a lot of leaks, not a lot of inside information gets out of the court on many subjects. So Justice Kennedy, I've mentioned earlier up at the top of the episode, he's 81 years old. and he's been on the court for more than 30 years at this point. He's the longest currently serving justice and the last Reagan appointee to remain on the court. And before that, before his service on the Supreme Court, he was a judge on the Ninth Circuit Court of Appeals for almost 13 years. So he's got over 40 years of service as a federal judge, leading to his retirement today. Now, he came to particular prominence after Justice O'Connor's retirement in 2006. Now, prior to her retirement, Justice O'Connor was referred to as the swing justice on the court. And what does that mean? Well, Justice O'Connor was the median justice, meaning if you kind of line the justices up ideologically from left to right, Justice O'Connor was the judge who fell smack in the middle of that of the 9 justices. And those type of measurements of political ideology, they're very imprecise, and there's a lot of disagreement about how to do it. But it's not that hard to give kind of rough estimate of left to right. There may be some quibbling over certain pairs of justices, which one is slightly more liberal or slightly more conservative than the other. But it's pretty clear that Justice O'Connor for quite a while was the median justice. And upon her retirement and being replaced by a more conservative justice, Justice Kennedy fell into that slot. And both O'Connor and Kennedy were referred to often as swing justices because they didn't the court in both during both times the court was generally divided basically 5-4 on more conservative leaning justices and more liberal leaning justices. But both O'Connor and Kennedy had a history of sometimes siding with the more liberal wing of the court in certain areas in certain cases. So they were kind of considered the swing justices on the court. Now, Justice Kennedy, once he kind of assumed this median position, he was still looking at his record overall, was clearly a more conservative justice. He more often sided with the conservatives in kind of contentious cases, but he did definitely side with the liberals in certain key areas, and which made him important to the maintenance of a more liberal position in certain areas of the law. Now, it's interesting because this position as the swing justice, the median justice, is kind of double-edged. It gave Justice Kennedy a great deal of power. He had a lot of ability to potentially shape the court's opinions or write very influential concurrences because of his position there in the middle of the case. He was extremely frequently, when the court was divided 5-4, he was in the majority very frequently. It was unusual for him to be in the minority on the dissent on those 5-4 divided cases. So though it happened from time to time, but he was often in the majority, so he had a lot of opportunity to kind of wield his influence, especially as he was the vote that was often sought by litigants who thought that it was a case that might split along ideological lines. Well, Kennedy was the vote that a lot of people hoped to get to sway to go one way or the other. But on the other hand, that position allowed him to kind of shape cases and when he wrote for a divided court, to kind of demand certain compromises or to hold out somewhat idiosyncratic positions, and was able to hold that line because of the concern that against losing his vote. But that very kind of power may make some of his decisions more vulnerable to kind of losing their influence once he's no longer left on the court, because he may lose opinions that once he is gone, there's really no one left on the court who really believes full-throatedly in the position as it was written by Justice Kennedy, as it was actually taken. So that was seen after Justice O'Connor left. A lot of her kind of very kind of signature positions that she had staked out as the median justice started kind of being whittled away at or overruled one by one, and so the influence she wielded as the swing justice made her somewhat more vulnerable to kind of fading away once she was no longer in that position and no longer on the court. So, what's the legacy of Justice Kennedy? The most prominent area that gets brought up a lot is in the area of gay rights, where Justice Kennedy kind of staked himself out as the key player in a number of decisions. There were basically four major gay rights decisions, starting with Romer v. Evans in 1996, which dealt with a state constitutional amendment which had prohibited the inclusion of sexual orientation as a protected category under anti-discrimination law, and that was overturned by the court. And later, Lawrence v. Texas in 2003, which found unconstitutional state bans on homosexual sexual activity, and then later Windsor v. U.S. in 2013 and Obergefell v. Hodges in 2015, and those are the two cases that, with Obergefell, resulted in the legalization of same-sex marriage nationally across the United States. And in all of those cases, Justice Kennedy wrote the majorities for the court. And so he clearly saw this as his part of his legacy and one of his major areas of great influence on the court. But another area where he was kind of stood out somewhat is the area of free speech. He arguably had the most expansive view of free speech of any of the justices on the court. And this includes the kind of more traditional areas of free speech, protecting political dissent and things like that, but also areas that have become much more common in recent years, but are much more controversial, especially among the political left, including things like campaign speech and more heightened protection for commercial speech, speech in advertising and in the commercial sphere. And interestingly, it was in this final term of his that it seemed like these two areas where he'd really staked out, made his mark and kind of staked out a claim as a champion, free speech and gay rights, kind of seemed to come to a head, at least as the case was often framed in Masterpiece Cake Shop. And some argue that that's kind of the reason the case was decided as it was that Justice Kennedy just didn't want to tar his legacy in either of those two areas with a decision that would have cut back in one way or another on his kind of gay rights legacy or his broad free speech legacy, and that that some have argued that kind of led him to look for a way out in that in its final term. But that's just, again, speculation. Now, Justice Kennedy was known for his particular style of opinion writing, which was not always he was not always considered one of the sharper stylists on the court. His style was often described as florid. It was kind of subject to a lot of criticism for what was sometimes regarded as overblown language. A particular phrase that comes from Planned Parenthood v. Casey, that's an important abortion case from the early 1990s. There was a line that says, and I'll quote it here: "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." And that line became famous. It was later derided by Justice Scalia as the sweet mystery of life passage, and kind of got a lot of criticism as kind of some hand-wavy philosophy. And even people who were in favor of his results, so even, for example, people who were very happy with the results of a case like Obergefell legalizing same-sex marriage nationwide, some expressed a lot of displeasure with the actual way the opinion was written, and specifically about the legal analysis, which was considered by many to be very unclear as a doctrinal matter, and not laying down either clear rules to be applied in future cases or a clear approach of how to analyze the particular issues in a case. So it's unlikely he'll be regarded as one of the court's great legal writers or stylists as part of his legacy. Although, on the other hand, because he was the author of some of these very influential or very important opinions in the gay rights sphere, some have seized on some of these passages that have been described by some lawyers as overwrought. Some have seized on them as they've been used in for example in in wedding ceremonies as in language describing the importance and sanctity of marriage from his Bergenfeld decision, for example. So it's maybe it's in the eye of the beholder. So Justice Kennedy, he's on his way out the door. So that obviously leaves the question about what happens next. Who will be his replacement? Now, President Trump has said that he is going to stick to his list of 25 judges that he has proposed and named as his candidates, his short list for the Supreme Court vacancy. Now, this is a list he had previously for the Justice Scalia vacancy that was eventually filled by Neil Gorsuch. He had proposed first during the presidential campaign a list of, I believe, 10 or 11 names, and then a later supplemental list. He added another 10 or 11 names. So he had a list of, I believe, 21 names at the time to choose from. Later, after Justice Gorsuch was confirmed, at some point, he released another supplemental list of another 5 judges, so bringing the total up there when you remove Neil Gorsuch to 25 names on his candidate list for this spot. Almost all of them are current judges, federal and a few state judges, and already because of the names of these judges are out there, there have been kind of vetting campaigns already underway by various organizations on both sides, looking into these judges and kind of assembling research, opposition research, and research and support. And already there are public advertising campaigns gearing up ever since Kennedy's retirement yesterday. There's already been a lot of action on both sides, kind of gearing up to really have a big public push, either in support or in opposition to whoever ends up being named by President Trump as the nominee for this position. And it appears that the same main advisors that guided the Justice Gorsuch's selection before are involved in right now. Don McGahn, the White House counsel, and Leonard Leo, who's the executive vice president of the Federalist Society, and that's an organization of lawyers of primarily conservative and libertarian lawyers, and he's someone who's very tied in due to that position with the conservative legal movement broadly, and they appear to be again the primary advisors on President Trump's selection. And there have been some in the past day since Kennedy's announcement. There have been some short lists floated of 5 or so people on the list who are supposedly the top contenders that are being considered right now for this position, but there'll be a lot more news about that as the process plays out. So what's going to happen now? In theory, there's enough time right now, depending on how fast things move with the Senate, and assuming the Senate works on this through the summer. There's time for someone to be nominated and confirmed prior to the start of the October term. And it appears that there's the efforts are underway by Senate Republicans and the Trump administration to try and move things so that does happen, but it remains to be seen. Now, due to the Senate maneuvering during the Gorsuch nomination process, the filibuster on Supreme Court nominees was eliminated. So meaning that the confirmation of whoever gets nominated will only take a bare majority in the Senate. There'll be no opportunity for a minority to filibuster the confirmation. So that limits some of the options to Democrats looking to block a Trump nomination to the court. The Republicans have only a very narrow majority. It's a 51-49 in the Senate. So there'll be efforts to try and flip a more moderate Republican or somehow leverage to push the administration toward a more a less conservative nominee. At this point, it seems like commentators think that that's unlikely to be successful. But again, everything remains to be seen. But then there's a lot of talk about other procedural tactics that the Democrats might be able to use to impede or delay the confirmation. Things they can use to slow down the Senate, to require much more time to be spent to kind of drag things out. Of course, given the high importance that Republicans have clearly given to judicial nominations generally, but the Supreme Court in particular, any use of those tactics might lead to the Republicans kind of further using the so-called nuclear option to implement rule changes to remove any of those procedural tools that the Democrats attempt to use. That would require keeping all of the Republicans on board for that kind of strategy, because the majority is so narrow. But that's potential ways that this might play out. But it seems like there's at least a strong possibility that the Senate majority and the president will be able to get this confirmation completed prior to the start of the term in October. But again, that's a ways off right now, and who knows how the whole process will play out, both in the court of public opinion and in the Senate. Now, what's going to happen when Justice Kennedy's replacement comes on? Well, we don't know who it's going to be. There's 25 potential justices on that list, and they're not all the same. They all are well established in kind of conservative legal circles. But one thing that it's been said many times before by justices on the court is that the addition of any new justice can make it a whole new court. Any change in court personnel can lead potentially to some unexpected realignments. A new justice can introduce new approaches or new priorities or emphases that might change the way doctrine is shaped or the way other justices view certain cases. And it's not just about the voting, about the specific positions they take, but the ability and willingness of a particular justice to work with other justices to, for example, to reach agreement on specific language and opinions, or to come to compromises. And this is arguments are made that the interpersonal relationships matter a lot on the court also. The ability to get along with other justices may lead someone to have more influence on the court. Or looking at it from the opposite direction, there's the question of which of the current justices on the court will be most able to influence the new justice, whoever he or she is that comes on board. And so it's impossible to predict exactly how this will all play out. But a lot of the attention has been on Justice Kennedy's major 5-4 decisions in which he sided with the liberal wing of the court, because these seem like the areas that are most vulnerable to a change upon the confirmation of a more conservative justice. Now, according to Adam Liptak, the Supreme Court reporter for the New York Times, there have been 51 cases with this pattern where it's Justice Kennedy plus the liberal justices in the majority. So that's kind of the universe of the kind of high-risk cases to result in a flip upon the confirmation of a more conservative justice. I'm going to talk just about 3 of the most high-profile areas. And the first one is obviously abortion. Now, Kennedy was not a consistent vote with the liberal side in the abortion cases. Just for example, he wrote the majority opinion for the court for the court's conservative wing in the 2007 case called Gonzalez v. Carhart, and that was a case that upheld the constitutionality of the federal partial birth abortion ban act. So he has in some cases like that, he has sided with the conservative side in those cases. But he has, in multiple occasions, been a crucial vote also on the more liberal side in these cases. And key case is Planned Parenthood v. Casey from 1992. And that is the key case that endorsed Roe v. Wade's constitutional protection of abortion rights, while at the same time modifying the legal standard that had been originally established in Roe v. Wade, and leaving with the Casey standard that's now the governing standard in abortion rights cases. And in that case, Kennedy was the crucial 5th vote in the majority and co-wrote the majority opinion in that case along with Justices O'Connor and Souter. More recently, in 2016, there was a case called Whole Women's Health v. Hellerstedt. And that was a case involving so-called TRAP laws. That TRAP stands for Targeted Regulation of Abortion Providers. And that's a term for laws that impose regulatory requirements on abortion providers that while they're facially directed at medical health and safety concerns, according to abortion rights proponents, they're actually intended designed to burden abortion providers and reduce the availability of abortion services. That's this concept of trap laws, and that was what was at issue in Whole Women's Health. And Kennedy, in that case, joined with the 4 liberal justices in the majority, finding certain key portions of the Texas law that was being challenged unconstitutional. So, he's been a significant vote in some of the abortion cases. The replacement of Kennedy with a more conservative justice could result in significant changes, which might be just allowing additional regulation of abortions, for example, along the lines of the Whole Women's Health case and these trap laws. But it could even potentially mean overruling Roe v. Wade and Casey altogether. Those are certainly possibilities that are out there with a more conservative justice in his place. Another area is affirmative action. Now, in affirmative action cases, Kennedy had typically voted with the conservatives in opposing race-based affirmative action programs. And just as an example, the important cases in 2003, there were a pair of cases called Grutter v. Bollinger and Gratz v. Bollinger. And the Grutter case upheld the University of Michigan Law School's affirmative action program, while the Gratz case struck down the University of Michigan's undergraduate affirmative action program. And those were both decisions were 5-4, with O'Connor as the swing vote, kind of going one way in one case and going the other way in the other. But Justice Kennedy voted against both programs. He was in the opposition to those programs in both of those cases. But there was a major recent case that went the other way, and this was a case called Fisher v. University of Texas. And that was a challenge to the University of Texas at Austin's affirmative action program. And in that case, Kennedy voted with the liberal justices to uphold that program. So, the replacement of Kennedy this is another space where the replacement of Kennedy could, result in a solid 5-justice block against race-based affirmative action programs. Now, a major focal point in affirmative action litigation right now is about allegations of discrimination in college admissions against students of Asian ancestry. And the case kind of framed in that way could make its way to the Supreme Court in the next few years. So that's something that may be on the table with a new conservative justice. And then again, there's gay marriage, the area that we had talked about before. The two key gay marriage cases are Obergefell v. Hodges, and before it, the Windsor case. Both of those were 5-4 decisions. And, a more conservative justice could theoretically take steps to reverse or cut back on that right. Now, there's no way of knowing exactly how these areas would play out. Different potential nominees have, various divergent views. Many of them haven't taken public positions on a lot of controversial topics. And there are some divergent views on many issues within the kind of broad conservative legal movement. If I had to just give a gut assessment based on what I've seen and kind of the array of opinion, I would say that the kind of diversity of views and is most true with respect to the same-sex marriage case. Actually, the pro same-sex marriage position had a number of very prominent conservative defenders. These include, for example, the co-founder of the Federalist Society, Stephen Calabrese, a professor who wrote an article in defense of a constitutional right to same-sex marriage before Obergefell was decided. And also, there's the popular opinion, which has continued to shift in favor of same-sex marriage and reached record highs, new highs of approval levels in 2018. So, that's reason to think that may be a area that's less likely to be overturned even by a more conservative justice. Though there's still certainly many in the conservative legal world that hold opinions in the opposite direction. I think the area that's probably in most danger is probably the race-based affirmative action area, where there's among the conservative legal community there's a fairly widespread endorsement of a colorblind approach to race-based programs, including affirmative action programs. So that seems like an area that seems very likely to be to be subject to change under a different justice. And abortion seems somewhere more in the middle. There are a lot of conservatives who are very unhappy with the Roe v. Wade decision and the subsequent abortion case law after that. But there are many who seem to have no real stomach to actually overturn it, while at the same time, others are eager to do so. So it's anyone's guess whether exactly what the result would be, but it could be anywhere from some slightly more modest restrictions to wholesale overruling. Of course, the composition of the court might change further before any of these issues reach the justices. Cases come to the court as they come. The court has, some ability. The court can pick and choose which of the cases that are presented to it takes, but it only has the options of those cases that people bring to it in any given year to choose from. So sometimes it takes a while before a particular case that really presents one of these issues squarely makes its way up to the court. So we don't know how soon the court will have the opportunity to rule on these particular issues. But in any case, there's a very real possibility of major changes to the doctrine in these areas, including possibly wholesale overruling. But that remains to be seen in the future. Just something to watch as we go forward. And I think I'll close with that. That brings us to the end of this live stream episode. With the end of the term here, this podcast is going to go on hiatus for a bit. I'm not sure exactly when I'll be back, so I strongly encourage anyone who hasn't done so already to please subscribe either to the Counting to 5 YouTube channel or to the audio podcast to make sure you don't miss anything when we return. And as always, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page, tweet at countingto5, or send an email to mike@countingto5.com. Please send me feedback. I'd love to hear whatever you have to say about the podcast. I want to conclude by thanking everyone who's been following the podcast, and especially those of you who've reached out with comments or questions or feedback of any kind. I really appreciate hearing from listeners, and if you haven't done so already, it's never too late to leave a comment, shoot me a quick email. I make an effort to respond to everyone, and I really hope to hear from you. And with that, thank you for listening. This has been Counting to 5.